One of the other issues that we had identified on our list was about the Fourth Amendment, this idea that you want to have protections against the government coming in and taking things from you without your permission. So under the Fourth Amendment, you're protected against illegal searches and seizures. This is why you hear police, needing a warrant to enter into your residence. You need people, the government has to do something in order to get permission to get access to your information, your data, or your physicality, or whatever it is. Even to draw a blood sample, they may need to get a warrant in order to do that in some situations. So this case comes from Judge Amy Coney Barrett's Seventh Circuit, and here is what we're looking at. This is United States versus Watson. So this case was published on August 17th, 2018, also from the Seventh Circuit, and it's a case where the police received an anonymous 911 call from a 14-year-old who borrowed a stranger's phone and reported seeing boys playing with guns by a gray and greenish Charger in a nearby parking lot. That's important. Very, very non-specific. Seeing boys, quote, playing with guns by a gray and greenish Charger. Police officer then drove to the lot, blocked a car, went up there. They found a passenger in the car who was David Watson, who had a gun. He later pled guilty, but then he appealed the case, saying that the court should have suppressed the gun because the stop lacked reasonable suspicion. All right, so this is important. What does that mean? Reasonable suspicion. So the cops just can't come up to you and just start investigating you for no reason. There has to be some sort of suspicion, and it needs to be reasonable. If it's unreasonable suspicion, that doesn't count. It's got to be reasonable under the circumstances, and there needs to be something. This came out of case law because people were kind of sick of being harassed by the police, largely during the civil rights sort of era. Cops would just go up to people, African Americans specifically, and just start harassing them. And they would say, well, you can't do that. I'm free to move around the world as we want. And then the Supreme Court started really sort of getting granular about what's okay and what's not okay in terms of getting harassed by the police. So this case is coming out of that, right? This guy is sitting in his car. Some anonymous person makes a 911 call, says there's boys playing with guns over there. So the cops show up, and this guy gets prosecuted. He actually ends up pleading guilty and appeals the case for further proceedings in the Seventh Circuit. So Amy Coney Barrett comes back and says, we agree with Watson. The police did not have reasonable suspicion to block the car. The anonymous tip did not justify an immediate stop because the caller's report was not sufficiently reliable. The caller used a borrowed phone, which makes it difficult to find him. His citing of guns did not describe a likely emergency or crime, and he reported gun possession, which is lawful. We therefore vacate the judgment and we remand it down for further proceedings. And so, excuse me, that sounds good, right? I mean, it sounds like, okay, so the cops were overstepping their boundaries, and Amy Coney Barrett said, no, not so fast. You actually have to go back and you have to, basically suppress the gun. Therefore, you are no longer going to be charged with a crime. And so as that happens, you may say to yourself, hey, that's great, right? That's strongly in favor of search and seizure law of the Fourth Amendment. That's great. We want more of that. But if you read further in the opinion, she says, this one falls on the wrong side of the Fourth Amendment, but it presents a very close call. That's language from the statute. In my opinion, it's not even close. This is not that close. It's not close at all, really, right? This was almost no information from the 911 caller. There were boys playing with guns by a gray and greenish Charger. There's no evidence of any criminality there. There's no evidence that he was breaking the law. There's nothing on the face. Even if you said, hey, that's true, right? There's boys playing with guns by a gray and greenish Charger. Like, what does that even mean? Is that illegal? It's okay to have guns. Presumably where this was, it was lawful. It was, it wasn't prohibited. So is it even a close call? I mean, in my opinion, no. But she goes through, great length and says this one falls on the wrong side of the Fourth Amendment, but it presents a close call. And she does some distinguishing, and so it's a little close. Some people would say that's a great thing because she found against the police in this case, but it was so close that if just a couple facts change, I think she's going to be finding in favor of the police. And this is a case that is a big deal. Anytime the police can come and start taking things from you or encroaching on your individual liberties and your freedoms, that is a big intrusion, in my opinion. And I'd like to see a nominee who supports that a little bit more, I would say, strongly.